May it please the court, my name is Chosu Kim, representing the defendant appellant Sonic AI. Your Honor, Sonic AI's intermediate copying constitutes fair use because its purpose was fundamentally transformative, converting expressive artworks into non-expressive data to create a new functional tool without usurping the cognizable market for the original works. I'll make 2 points today. First, I'll explain why Sonic AI's use is transformative under the first fair use factor. Then, I'll address why that use causes no cognizable market harm under the fourth factor. I'll begin with the purpose and character of the use. Turning to the first factor weighs decisively in favor of Sonic AI. The intermediate copying at issue was functionally and commercially transformative, serving a purpose fundamentally different from that of the original works. This conclusion follows from two related reasons, beginning with the fundamentally different function of Sonic's use. Sonic's use is transformative because it creates a functionally distinct new product. While the original works serve an aesthetic purpose, Sonic utilizes them strictly as raw inputs to engineer a computational model capable of recognizing statistical patterns. In this respect, this intermediate copying aligns with Google Books and Oracle, where copying was a necessary step to create new functional tools. Importantly, recent rulings in Cadre versus Meta and Bartz versus Anthropic extended this logic to AI, holding that ingesting copyrighted content to analyze patterns constitutes fair use. Sonic's case mirrors this factual predicate. It utilizes Apelli's works to derive mathematical weights, creating a distinct functional utility rather than to substitute the artist's expression as seen in Warhol. Accordingly, under the established rule that functional analysis is transformative, Sonic's copying is protected. This distinction is critical because this use is distinct from the artist to artist expressive substitution in Warhol or mere retransmission to the same market as in TVIs. Sonic did not represent Apelli's works, it consumed them as raw data. That functional difference leads directly to my second point under the first factor. Your Honor, the resulting platform targets a different audience and use case, enabling non artists to create rather than supplying finished art to consumers. As a result, this furthers copyright's constitutional purpose to promote the progress of science and useful arts by expanding creative participation. Restricting the non expressive analysis of data would chill innovation in a critical technological field, contrary to the public interest. For these reasons, factor one strongly favors fair use. I'll now turn to the fourth factor, which independently supports the same conclusion. Under the fourth factor, appellees demonstrate no cognizable harm to the market for the original works. Therefore, it strongly favors fair use. There are two reasons for this, beginning with the absence of any actual market harm. First, Sonic's intermediate use did not usurp the primary market for Apelli's art. The training copies were not publicly displayed, distributed, or sold, and therefore did not act as a substitute for the originals. In other words, as in Google Books, Sonic's use remained entirely internal and non consumptive. That absence of substitution is fatal to Apelli's market harm theory, and it also undermines their claim of harm to a so called potential market. Second, Apelli's claim of harm to a potential market for AI training licenses is circular and legally insufficient. A transformative use does not cause cognizable harm merely by displacing a hypothetical licensing market that would only exist if the transformative use were prohibited. Put simply, Apellis cannot create a derivative right and then claim market harm when a transformative user does not pay for it. Moreover, the speculative harm to this nascent licensing market must be weighed against the certain public benefit of fostering a new transformative market for AI enablement tools. Foreclosing this non expressive use would stifle innovation, a harm to the public interest far exceeding the speculative loss of a hypothetical license fees. In closing, Sonic AI's intermediate copying is fundamentally transformative as it functionally converts expressive artworks into non-expressive statistical data, creating a novel creative tool rather than exploiting the original's aesthetic value. At the same time, this internal analysis creates no competing substitute in the market for the original works, and the speculative loss of potential licensing fees must yield to the substantial public benefit of fostering technological innovation. Accordingly, affirming fair use in this context aligns with the constitutional objective of copyright law by promoting the progress of science without usurping the creator's legitimate expressive markets. For these reasons, Sonic AI respectfully asks the court to conclude that the intermediate copying at issue constitutes fair use. Thank you.
Okay, thank you. Council, Sonic AI wants to make comics and also targets the Web2 market. Similarly, the artists, they also want to enter the Web2 market. Under Warhol, if the purpose is the same, fair use usually fails. So why isn't Sonic doing the same thing as the artists?
Thank you, Your Honor. Warhol dealt with public use of art, a picture showed in a magazine. Here, Sonic's copying happened inside the computer, not in public. The facts show that Sonic AI did not show the artist's works to users, did not sell the artist's works, used the images only to analyze patterns and turn them into numbers. This is like Google Books, where books were copied to analyze information, not to replace reading the books. So the purpose of copying here was data analysis, not publishing art. That is different from Warhol, Your Honor.
Council, in Ross, AI training was not found to be fair use because the AI was built to compete in the same market. Sonic AI also trains AI and also sells a product. So why isn't our case the same as Ross, and why shouldn't we not follow the case precedent Ross is giving us?
Your Honor, in Ross, the AI copied Westlaw summaries to build a direct replacement for Westlaw's legal research service. Here, Sonic AI did not copy finished editorial content like summaries. Sonic AI did not build a replacement for the artist's works. It only used images to learn general patterns like line thickness and shading. This is closer to Google Books and Cadre, where training AI was allowed because the AI did not reproduce the original works and there was no proof of market harm from the training itself. So Ross is different because it involved direct competition in the same service, which is not what is happening here with Sonic AI.
Okay, thank you, Council.